He's coming, Your Honor. Reported, sir.
Okay, good morning. Mr. Williams, you were arrested pursuant to an arrest warrant. It was issued June 3rd. It's charging you with aggravated battery with a firearm. And you have two attorneys here, or is it two attorneys in the state. Go ahead. You want to announce again?
Brad Cohen and Sam Zegny for the defendant.
Right. Have you had a chance to review the arrest warrant?
Yes, Judge, we have.
Let's review as well. Okay, I've had a chance to review the arrest warrant. Any argument, counsel?
Yes, Judge. Thank you, Judge. Judge, if you notice in the police report or the A form, it definitely isn't probable cause, in my opinion, for aggravated battery with a firearm. There's no intent shown in that document. There's no words that were said. There's no pointing of the firearm at anyone. Essentially, what the document says and what the witnesses said on that day is that the defendant was being escorted out of the club. He reached for his pockets, looking for money in his pockets. A weapon was pulled, and it was fired at the ground. And after it was fired at the ground, allegedly the ricochet or whatever happened was one of the either security guards or an employee of the club was struck in his ankle. Certainly, it doesn't show up any intent to injure that individual. I think it looks to me like an accidental discharge. But even if we stepped it up from an accidental discharge and said it was some sort of reckless discharge, it still wouldn't have the probable cause to charge him with an aggravated battery with a firearm. There's no witness that says at least even a word that the individual would say, like, hey, I'm about to do something, or something to demonstrate some kind of intent other than an accidental discharge. It doesn't appear that there was anything that would have prompted some sort of intent from the defendant.
Okay. All right, so let me hear from the state.
Judge, the state disagrees with that version of the facts. I mean, this is pretty clear from the arrest warrant. What happened here was the defendant was angry because the victim in this case, who was a security guard, told him to put away his gun. He then grew angry. He pointed the gun at him and shot him. The victim specifically states in the arrest warrant that he had to move out of the way. He was directly shooting at him. The only reason he got shot in the ankle was because he jumped out of the way at the last minute. This happened in front of a club full of people. There's video of the defendant with the gun in his hand. He has a prior pending open case right now where he's also with a gun and two people were shot. So, Judge, we're going to be asking for no bond on this.
And Judge, if I may, I'm not sure if you're reading the narrative from when the first police officer went out and took statements. But the first police officer that went out and took statements, it clearly says that he shot into the ground. There's nothing in the first statement that says anything about that he pointed it at anyone. And I don't know what the follow-up is, because all we have is the narrative, the police report narrative, that specifically says that there was something about money that fell out of his pants, and there was a witness. His name, I won't mention his name, but he advised security staff that he escorted the individual out, and the individual had a firearm out and shot towards the ground. That's what the independent witness stated.
Yeah, Judge, and this is Sam Zane on behalf of Mr. Williams. 2 points of clarification here. The alleged victim sustained a gunshot wound to the ankle. I don't know how you survive getting hit in the torso by jumping out of the way and get shot in the ankle. And that's buttressed by the fact that the original witness said that the firearm was discharged towards the floor. That's the first point. The second point is that the allegations of the previous case, two people were shot, but
I
Mr.
remember,
Williams,
Mr. Zhang, I remember.
is not the shooter. Correct, Judge. This is a bondable offense. If there are issues with bond, it should be addressed by the court, the circuit court judge, with regards to the first case. Aggravated battery with a firearm is not a non-bondable offense. Just so the court knows that we've been in communication with the government. We surrendered Mr. Williams to Metro-Dade Detective Soto yesterday at TGK. We self-surrendered him. He wasn't arrested out and about as a fugitive on the run. We self-surrendered him just like we did last time. He's not a flight risk. And we believe the standard bond's appropriate in this case, Judge.
And Judge, if I may add to that, I mean, this is we've let defense counsel know that he was supposed to turn himself in last week. We gave him the opportunity. They didn't turn him in. He, as far as we were concerned, was a fugitive for the last week. The arrest warrant was signed, apparently, I believe it was on Tuesday or Wednesday. They've been looking for him, and they've turned several times where he was supposed to turn him in. They canceled.
He's here
again,
now.
Judge,
What's the
yes, Judge?
This is an aggravated battery. He's entitled to a bond. The standard bond is $10,000, and that's what I'm setting. The $10,000 bond with the hold for the division judge. Hold him for case number F20.